Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Martin Luther King, he died for us. Malcolm X died for us. Marcus Garvey deported for us. And Marcus Garvey was given an executive order pardon by President Biden as he left. Yes, our civil rights leaders, they have paid the price. President Trump, he wants to reverse, started to reverse in his first term as the 45th, and now in his second term as the 47th President of the United States of America. I call him KKK Russian Trump. KKK because he has the ideology from his family, his attitude towards people of color. They all signal that KKK Russian Trump will do whatever is necessary to destroy people of color. What he says most times is not what he does. He's one of those guys that sneaks up on your back telling you you're a nice guy and have a knife up your back. Is that how a capitalist works? What is KKK Russian Trump? With the oligarchs that he's working with now, if you understand the theory of Karl Marx, it signals the end of capitalism. Is KKK Russian Trump truly a capitalist or a communist? My name is Brian Figueroa of the law firm Figueroa and Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Visit our website, the law firm of Figueroa and Associates, at www.askthelawyer.us. Again, www.askthelawyer.us. What we do is educate our clients. At our website, you will see hundreds of articles. Articles with our Caribbean American weekly publication, New Black Voices, the Immigrants Journal, and Workers' World Today. We need you to be educated about life, about money, about progress. We need you to understand and interpret things that obviously Congress passes and the executive executive orders of KKK, Russia, and Trump. He did many of them. He's going to do more, and none of those executive orders are consistent with what he said in the past in terms of how he sees people of color, what he wants to do for America, whether they are black, white, or brown. Yes, when you put taxes, excise taxes on goods and services, we pay, the consumer pay, the general public pay. What is he going to do with that money? Who does it benefit? And why does he want to put 25% tax on Mexico and Canada? Yes, we will pay. It's called inflation. And I hope Wall Street understands this, because Wall Street's supposed to go down, not up. Unless, obviously, the Wall Street people don't understand basic economic theory. That is what lawyers do for their clients. They have to understand the facts, understand the law, and represent their clients properly. That's why we tell our Chapter 7 clients who file for bankruptcy, it is better to get rid of the debt if you can than to consolidate. When an attorney tells you Chapter 13 rather than Chapter 7, and common sense says to Chapter 7, that attorney may want to bill you more money, but at what cost to you, the consumer? When you get a divorce, should it be contested or uncontested? Does the attorney understand issues of equitable distribution in New York State? Does the attorney understand that you don't divorce your children? You don't divorce your money. You divorce your spouse. As far as immigration issues are concerned, we want litigation against KKK, Russia, and Trump on all his executive orders. He understands that the 14th Amendment gives people the right, if they have a child in this country, a child born in this country is a U.S. citizen. He believes that he's above the U.S. Constitution. That's why organizations like the American Civil Liberties Union obviously will challenge his executive order. Is it arrogance? Is it stupidity, ignorance, that he doesn't understand the laws of the United States of America? If he has contempt for the Constitution, what does he have for federal and state laws? Is that an additional contempt he may have, that he thinks he's above the law? People who think they're above the law are normally common criminals. And those common criminals, like the ones that he pardoned, almost 1,500 of them, not only did they destroy property, but 4 law enforcement people died in Washington. So he doesn't even respect law enforcement, law and order. What type of president in the United States of America in modern times could do things like this and get away with it? Unfortunately, a lot of people voted, 48 out of the 50 states, they voted for KKK, Russia, and Trump. What does that say about the general public? What does it say about what is our motivation? Do we read and understand why we vote and who we should vote for? There's one religion that comes to mind. The one that this guy from Mission Impossible, what's his name, belongs to. This Church of Scientology. They think only smart people should be allowed to vote. People who could read, people who could write, and people who could think. Is that a signal that obviously that we have a lot of stupid people in America? Well, we need to look at the educational system, because one of the areas that Trump wants to bring immigrants from other countries is the H-1B. That's for intelligent people. And America lacks intelligent people. And who is supporting it? The three oligarchs. Amazon, the car company, they call it Tesla. And what's the other one? Yes. Amazon, Tesla, and Facebook. Yeah. Facebook said that they're not going to, fact check anymore. But who needs facts when you have President KKK Russian Trump? So facts doesn't matter for the next 4 years. And hopefully, we will do better in this democracy to preserve it 4 years from now. My name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. When you give us a call, you deal with an intelligent law firm that understands the law, analyzes the law, and come to the best advice for you, our listeners. Again, the number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. The website for the law firm of Figueroa & Associates is www.askthelawyer.us. Again, www.askthelawyer.us. When we represent you, we give you a plan of action, which we follow, which is to the best to obviously represent you with the highest credibility, research, everything that will make your case successful. Thank you.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip. Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa & Associates, your trusted partner in U.S. immigration law for entertainers.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa & Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most.
Good day, good day, good day. My name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, number to share is 855-768-8845. Again, 855-768-8845. Religious petitions, immigration, yes. There are so many different churches in America representing people of color. And those churches are entitled to petition for religious workers. Every year, there's a quota of 10,000 green cards. However, that quota is never exhausted, which means you churches out there, you religious organizations, you are not using this special immigrant visa to bring your fellow religious leaders from the diaspora, the African, the Latino diaspora. So whether it be Latin America, Africa, the Caribbean, wherever, if you have an organized church, you can petition for religious workers from those countries to help you do your job here in America, which is spreading the word of God. Yes. And we know God has different, meanings, but U.S. immigration law does not, discriminate against any particular religion. So we're talking about all religious organizations that are 501c3 approved, meaning they are a bona fide nonprofit. So if you are a religious leader and you want to bring that pastor, evangelist, organist, whatever it is that is categorized as a religious worker, no non-religious work, please, and you want to bring that person to America, give us a call. And we will work with you to bring that person or persons to America so that God's word would be, properly taught. My name is Brian Figueroa of the law firm Figueroa & Associates. This is Ask the Lawyer. You got questions, we got answers. The number to call, the number to keep, the number to share with your religious leaders, churches, synagogue, whatever your religion. It's 855-768-8845. Again, 855-768-8845. Many religions established in the United States of America or imported from other countries, they have the right to religious freedom in America. And obviously sometimes the big guy or lady who really understands and can motivate people to God, they are what in other countries. But you could bring them here. You could get them a green card. You could bring their families here so that they could make a transition to America in a much needed leadership position. Again, the number to call, the number to keep, the number to share is 855-768-8845. Again, 855-768-8845. Our website, www.askthelawyer.us. Again, www.askthelawyer.us. Thank you.
Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figueroa & Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figueroa and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figueroa and Associates today.
Are you looking to study in the United States but confused about how to apply for a student visa? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in guiding students through the visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand between you and your academic dreams in the U.S. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless students secure their student visas and begin their educational journey in the United States. Let us help you make your study abroad dream a reality. Figueroa and Associates, your trusted partner in student visa success.
If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most. Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report based on an article by attorney Brian Figueroa. The impact of President Trump's executive orders on political asylum applications, pending and new cases procedural analysis. Introduction. The U.S. asylum system has long served as a beacon of hope for individuals fleeing persecution, violence, and human rights violations in their home countries. Governed by both domestic laws and international treaties, the asylum process provides protection to those who meet the legal definition of a refugee, someone unable or unwilling to return to their home country due to persecution based on race, religion, nationality, membership in a particular social group, or political opinion. Executive orders, EOs, play a crucial role in shaping asylum policy by allowing the president to bypass Congress and directly implement changes to immigration enforcement and processing. During his tenure, President Donald Trump signed a series of executive orders that significantly altered the landscape of political asylum in the United States. These policies aim to curb immigration, strengthen border security, and restrict eligibility for asylum, leading to profound impacts on both pending and new asylum applications. This article aims to analyze how Trump's executive orders affected the procedural aspects of political asylum applications. We will examine the influence on cases already in process as well as newly filed applications, addressing critical issues such as processing delays, eligibility restrictions, legal challenges, and the broader implications for the U.S. immigration system. Key executive orders affecting asylum policies. President Trump's administration introduced several executive orders targeting immigration, many of which directly impacted asylum procedures. The most significant orders include 1. Executive Order 13,767, Border Security and Immigration Enforcement Improvements, signed on January 25, 2017. This EO aimed to enhance border security and reduce illegal immigration. It called for the construction of a border wall, increased detention capacity, and stricter enforcement of immigration laws. This order directly impacted asylum seekers by expanding expedited removal proceedings, limiting parole options for asylum seekers while awaiting case adjudication, increasing the deployment of border enforcement officers. 2. Executive Order 13,780, protecting the nation from foreign terrorist entry into the U.S., commonly known as the travel ban. This order restricted entry from several Muslim-majority countries and introduced extreme vetting measures. Though primarily focused on visa applicants, it indirectly impacted asylum seekers from affected countries by prolonging processing times and increasing scrutiny of their applications. 3. Executive Order 13,841, Family Separation Policy and Zero Tolerance. Issued in June 2018, this controversial policy aimed to deter illegal immigration by prosecuting all individuals who crossed the border unlawfully, resulting in widespread family separations. Asylum-seeking families were heavily affected, as children were separated from parents and legal procedures were delayed or complicated by the separation process. 4. Additional executive actions. Beyond formal EOs, the Trump administration implemented other policy changes, such as the Remain in Mexico program, migrant protection protocols, which forced asylum seekers to wait in Mexico while their cases were processed in U.S. courts. The administration also sought to redefine eligibility criteria, making it harder for individuals to qualify for asylum. Impact on pending political asylum applications. The implementation of these executive orders had profound consequences on pending asylum applications, exacerbating an already strained system. Some key impacts include: 1. Increased backlog and delays. The asylum backlog surged during the Trump administration, with cases taking years to be processed due to new enforcement measures. The introduction of policies such as last in, first out processing further complicated the situation, forcing older cases into indefinite limbo. 2. Enhanced vetting measures. Executive orders imposed stricter background checks, increasing the burden of proof on applicants. Individuals were required to submit more comprehensive documentation, which led to procedural delays and increased scrutiny, often resulting in denials based on technicalities. 3. Administrative challenges and increased rejection rates. The denial rates for asylum cases rose significantly as adjudicators applied more rigid criteria and interpreted asylum laws more narrowly, particularly regarding claims related to gang violence and domestic abuse. 4. Impact on legal status and work authorization. Many pending applicants face difficulties in renewing work permits and maintaining legal status while awaiting decisions, putting them at risk of deportation and economic hardship. 5. Access to legal representation. Asylum seekers encountered greater obstacles in securing legal counsel, with many nonprofit organizations overwhelmed by the influx of cases and changing policies that made representation more complex. Impact on new political asylum cases procedurally. For new asylum applicants, the Trump administration's policies presented additional hurdles and procedural changes that reshaped the application process. 1. Stricter eligibility criteria and credible fear interviews. The administration imposed tougher standards on credible fear interviews, which serve as the initial screening for asylum seekers at the border. Applicants had to demonstrate a higher likelihood of success in their full asylum hearing, leading to an increase in expedited deportations. 2. Changes to expedited removal proceedings. Under Trump's executive orders, the scope of expedited removal was expanded, allowing immigration authorities to deport individuals without a hearing before an immigration judge if they fail to prove their eligibility at the border. 3. Third country agreements and Remain in Mexico policy. Agreements with countries like Guatemala, Honduras, and El Salvador forced asylum seekers to apply for protection in those countries first before seeking asylum in the U.S. The Remain in Mexico policy subjected applicants to prolonged stays in dangerous border cities while awaiting hearings. 4. Denial rates and narrowing of persecution definitions. New guidelines redefined what qualifies as persecution, excluding claims related to gang violence, gender-based violence, and economic hardship. This change resulted in higher rejection rates and a significant decline in asylum grants. 5. Impact on vulnerable populations. Women, children, and LGBT+ individuals faced increased difficulty in accessing asylum protections due to the restrictive interpretations of asylum laws, leaving many at risk of harm. Legal challenges and responses to Trump's asylum policies. The executive orders issued by President Trump faced numerous legal challenges from advocacy groups, states, and international organizations. 1. Major lawsuits against asylum policies. The American Civil Liberties Union, ACLU, and other legal groups filed multiple lawsuits challenging policies like the travel ban and family separation, arguing that they violated constitutional and humanitarian protections. 2. Court rulings and injunctions. Federal courts frequently intervene to block certain provisions of Trump's asylum policies, though the administration continued to appeal decisions, creating legal uncertainty for applicants. 3. Advocacy and public response. Human rights organizations and immigrant advocacy groups mobilized to provide legal aid and public awareness campaigns to counter the negative impacts of restrictive asylum policies. 4. Congressional efforts. Some members of Congress introduced legislation to counteract Trump's asylum restrictions, though these efforts faced significant political resistance. Comparative analysis. Asylum policies before and after Trump won. Obama-era policies versus Trump's changes. The Obama administration focused on balancing enforcement with humanitarian concerns, whereas Trump's policies prioritized enforcement over protection. 2. Impact on the asylum system's integrity. The restrictive measures introduced during Trump's tenure led to a decline in asylum grants and an increase in procedural complexity, fundamentally altering the system. 3. Reversal of policies post-Trump. The Biden administration took steps to reverse many of Trump's policies, including terminating the Remain in Mexico program and reinstating more lenient asylum processing measures. Conclusion and future outlook. Trump's executive orders had a lasting impact on political asylum procedures in the U.S., creating challenges for both pending and new applicants. The increased scrutiny, procedural hurdles, and policy shifts resulted in longer processing times, higher denial rates, and greater hardships for vulnerable populations. Moving forward, policymakers must find a balance between national security and humanitarian obligations to restore fairness and efficiency to the asylum system. Comprehensive immigration reform, improved processing efficiency, and enhanced legal support for asylum seekers will be critical in rebuilding trust and ensuring the system remains a refuge for those in need.
Estate planning is a necessity, not a luxury. Let the law firm of Figaro & Associates help you protect your legacy, assets, and loved ones. Get estate planning consultation on wills, living trusts and probate, power of attorney, health proxy, deed transfers, providing for special needs, disabled children and grandchildren, minimizing federal and state taxes. Call us right now at 855-768-8845. That's 855-768-8845. Or schedule an appointment at www.askthelawyer.us. That's www.askthelawyer.us.
Are you planning a trip to the United States but unsure how to navigate the visa process? The law firm of Figaro & Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys will guide you step by step through the visitor's visa application process, ensuring that you have the best chance of success. Don't let paperwork and interviews stand in the way of your dream vacation. Schedule a consultation today by visiting www.askthelawyer.us or call 855-768-8845. We have helped countless clients like you successfully secure their U.S. visas. Let us take the stress out of the process so you can focus on planning your perfect trip.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figaro & Associates, and your presenter with a special immigration report. President Trump's upcoming executive orders on immigration and their impact on immigrants immediately taking office on January 20, 2025. President Donald Trump has signaled an ambitious agenda to reshape U.S. immigration policy through a series of executive orders. These directives are expected to have profound implications for documented and undocumented immigrants residing in the United States. This podcast analyzes the anticipated executive orders and their potential impact on immigrant communities. 1. Mass deportations. One of the most significant actions President Trump plans to undertake is the initiation of mass deportations targeting undocumented immigrants. Tom Homan, the designated border security official, announced that nationwide raids are scheduled to commence shortly after the inauguration. This initiative aims to deport millions of individuals without legal status, marking one of the largest deportation operations in U.S. history. Impact on immigrants. Family separations. The enforcement of mass deportations is likely to result in the separation of families, particularly affecting mixed-status households where some members are U.S. citizens or legal residents. The psychological and emotional toll on families, especially children, could be substantial. Economic disruption. Undocumented immigrants contribute significantly to various sectors of the economy, including agriculture, construction, and service industries. Their removal could lead to labor shortages, affecting productivity and leading to potential economic downturns in certain industries. Community trust. Increased immigration enforcement may erode trust between immigrant communities and law enforcement agencies, making individuals less likely to report crimes or cooperate with investigations, thereby compromising public safety. 2. Ending birthright citizenship. President Trump has expressed intentions to sign an executive order ending birthright citizenship for children born in the U.S. to undocumented immigrants or those on temporary visas. This move challenges the interpretation of the 14th Amendment, which has historically granted citizenship to anyone born on U.S. soil. Impact on immigrants. Legal uncertainty. Revoking birthright citizenship would create a class of individuals born in the U.S. without citizenship, leading to legal ambiguities regarding their rights and status. Statelessness. Children born to undocumented immigrants may become stateless if they do not acquire citizenship from their parents' country of origin, resulting in a lack of legal protection and access to essential services. Increased marginalization. Without citizenship, individuals may face barriers to education, employment, and social services, exacerbating marginalization and inequality within society. 3. Reinstating the Muslim ban. The administration plans to reinstate the travel ban affecting individuals from specific Muslim-majority countries, a policy initially implemented during President Trump's first term. Impact on immigrants. Family reunification. The travel ban would hinder the ability of families to reunite, affecting those seeking to join relatives in the U.S. Humanitarian concerns. Refugees fleeing persecution may find it challenging to seek asylum in the U.S., potentially leaving vulnerable populations without safe haven. Perception of discrimination. Targeting specific countries could foster perceptions of religious or ethnic discrimination, impacting the social cohesion and sense of belonging among affected communities. 4. Suspension of refugee admissions. The administration intends to suspend refugee admissions, reversing policies that had increased the number of refugees allowed into the U.S. Impact on immigrants. Resettlement agencies. Organizations involved in refugee resettlement may face operational challenges and funding shortages due to reduced admissions. Refugee populations. Individuals in refugee camps or conflict zones may experience prolonged displacement and uncertainty without the prospect of resettlement in the U.S. 5. Enhanced border security measures. Plans include shutting down the U.S.-Mexico border and implementing stringent border security measures to prevent illegal crossings. Impact on immigrants. Asylum seekers. Individuals seeking asylum may be denied entry, potentially violating international humanitarian obligations. Cross-border communities. Communities and economies that rely on cross-border movement may suffer due to restricted access and increased enforcement. 6. Termination of DACA protections. While not explicitly stated in recent announcements, the administration's stance suggests a potential termination of the Deferred Action for Childhood Arrivals (DACA) program, which protects individuals brought to the U.S. as children from deportation. Impact on immigrants. Loss of legal status. Approximately 700,000 DACA recipients, known as Dreamers, could lose protection from deportation and work authorization, disrupting their lives and contributions to society. Educational and employment opportunities. Dreamers pursuing education and careers may face uncertainty and barriers, affecting their personal development and economic stability. Conclusion: the anticipated executive orders represent a significant shift in U.S. immigration policy, emphasizing enforcement and restriction. The impacts on immigrant communities are multifaceted, affecting legal status, family unity, economic participation, and social integration. As these policies unfold, it is crucial to monitor their implementation and advocate for approaches that balance national security concerns with humanitarian principles and the foundational values of the United States. If your spouse has overstayed their visa and you want to help them obtain a green card, we can help. The process of adjusting status can be complex, especially if there was an overstay, but the law firm of Figueroa and Associates, located in Brooklyn, New York, has the experience and expertise to guide you through it. Our team of immigration lawyers will assist you every step of the way, from filing petitions to representing you at interviews. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Get the right legal help when it matters most. Are you a religious worker looking to come to the U.S. to fulfill your mission? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help you navigate the complex R1 visa process. Whether you're a minister, missionary, or religious professional, our experienced immigration attorneys can assist with every step, from securing a U.S.-based sponsor to filing petitions with USCIS and preparing for your consular interview. Don't let the paperwork stand in the way of your spiritual calling. Schedule a consultation today at www.askthelawyer.us or call 855-768-8845 to discuss your case with our legal team. Figueroa and Associates, your trusted partner in U.S. immigration law for religious workers. Call Figueroa and Associates today.
President Biden pardoned 5 activists and public servants on Sunday, January 19, 2025, including a posthumous grant of clemency to the civil rights leader Marcus Garvey, who mobilized the Black nationalist movement and was convicted of mail fraud in 1923. Civil rights advocates and lawmakers have long said that Mr. Garvey's 1923 conviction for mail fraud was unjust, arguing that he was targeted for his work. Congresswoman Yvette D. Clarke of District 9 in New York issued the following statement on President Biden's posthumous pardon of Marcus Mosiah Garvey for a 1923 conviction for the fraudulent use of the mail. I'm extraordinarily grateful for President Biden's action today to posthumously grant clemency to a true national hero of Jamaica, the most honorable Marcus Garvey. Garvey was a Jamaican-born Pan-Africanist leader who led one of the earliest Black civil rights movements in the Americas, founded one of America's first Black-owned shipping companies in the Black Star Line, and established a legacy that has persisted to this day. His advocacy for civil rights and the economic advancement of the Black community built the foundation of our modern civil rights movement and influenced many of our civil rights leaders, including Dr. King, who described Garvey as the first on a mass scale and level 2, make the Negro feel he was somebody. The first man of color in the history of the United States to lead and develop a mass movement. In his statement, President Biden emphasized the significance of the clemency granted. These clemency recipients have each made significant contributions to improving their communities, he said. For more on this story, including an interview with Dr. Julius Garvey's, Marcus Garvey's son, visit CaribbeanAmericanWeekly.com.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Guardianship in New York challenges when the guardian is an adult child living abroad. Guardianship laws in New York City, NYC, and New York State, NYS, are designed to protect individuals, commonly referred to as wards, who cannot manage their personal, financial, or medical affairs due to physical or mental incapacity. In cases where an adult child living outside the United States and not a U.S. citizen or green card holder is named as the guardian, unique legal, logistical, and ethical challenges emerge. This article examines the guardianship framework in NYC and NYS, explores the complexities of having a non-resident guardian, and outlines possible solutions to navigate these challenges. 1. Overview of guardianship laws in NYC and NYS. Legal framework. Guardianship in New York is primarily governed by Article 81 of the New York Mental Hygiene Law, MHL, and to a lesser extent, Article 17A of the Surrogates Court Procedure Act, SCPA. Article 81 Guardianship. Designed for adults who cannot manage their personal or property needs. Guardianship is tailored to the specific needs of the ward, with the court granting only the powers necessary to meet those needs. Article 17A Guardianship. Used primarily for individuals with intellectual or developmental disabilities. Unlike Article 81, this form of guardianship is more comprehensive and less tailored to specific needs. Types of guardianship. Guardianships in NY are categorized into guardian of the person, responsible for decisions about the ward's personal and medical care. Guardian of the property, manages the ward's financial affairs. Guardian of the person and property, oversees both personal and financial matters. 2. Requirements for becoming a guardian. General eligibility. To qualify as a guardian under NY law, the individual must be at least 18 years old. The person must have the ability to perform the duties assigned by the court. The court must determine that appointing the individual is in the best interest of the ward. Non-resident guardians. Non-residents can be appointed as guardians under NY law, but their status introduces additional complications. When the proposed guardian resides outside the United States and lacks legal residency, example, a U.S. green card or citizenship, the court may impose stricter requirements to ensure the ward's interests are adequately protected. 3. Challenges when the guardian is an adult child living abroad. Legal challenges. Immigration status. A guardian who is not a U.S. citizen or green card holder may face difficulties entering the U.S. to fulfill their guardianship duties. Without a valid visa, the guardian may not be able to attend court hearings, supervise care, or handle financial transactions. Court oversight. Guardians must periodically report to the court on the ward's well-being and financial status. A non-resident guardian may find it challenging to meet these requirements without physical presence. 3. Residency requirements for financial transactions. Banks and financial institutions often require guardians managing property to have a U.S. address or valid tax identification number. This poses logistical barriers for guardians living abroad. Logistical challenges. Coordination of care. Guardians are responsible for ensuring the ward receives proper care, which can include managing medical appointments, coordinating with care facilities, and overseeing day-to-day needs. Physical absence can make these tasks significantly harder. Time zone differences. Guardians living in a different time zone may struggle to communicate effectively with care providers, financial institutions, and legal representatives in the U.S. Travel limitations. Frequent travel to the U.S. may be financially or practically unfeasible, especially if the guardian has employment or family obligations in their country of residence. Ethical and emotional challenges. Cultural differences. Differences in medical and elder care norms between the U.S. and the guardian's home country may lead to conflicting decisions about the ward's care. Emotional distance. A non-resident guardian may find it harder to maintain a close, supportive relationship with the ward, potentially affecting the ward's mental and emotional well-being. 4. Court considerations in appointing non-resident guardians. The court must determine whether appointing a non-resident guardian is in the best interest of the ward. Key factors include the guardian's ability to fulfill duties. The court will assess whether the proposed guardian can effectively manage the ward's personal and financial needs despite living abroad. Proposed care plan. The guardian must present a detailed plan for overseeing the ward's care, including local support systems and communication methods. Alternative arrangements. If appointing a non-resident guardian is deemed impractical, the court may explore alternative arrangements, such as appointing a co-guardian or standby guardian based in the U.S. 5. Case study, hypothetical scenario facts. Maria, an 82-year-old NYC resident, suffers from dementia and needs a guardian to manage her medical care and finances. Her adult son, Daniel, lives in Spain and is neither a U.S. citizen nor a green card holder. Daniel wants to serve as her guardian. Challenges. Daniel cannot travel frequently to the U.S. due to his work obligations and lack of a long-term visa. Maria's bank requires her guardian to have a U.S. Social Security number to manage her accounts. The court questions whether Daniel can adequately supervise Maria's day-to-day care from abroad. Proposed solutions. Appointing a local co-guardian. A trusted family, friend, or professional guardian in NYC could be appointed as a co-guardian to handle immediate, on-the-ground responsibilities. Leveraging technology. Daniel could use video calls and remote monitoring tools to stay involved in Maria's care and communicate with her medical team. Standby guardianship. The court could designate a standby guardian in the U.S. to take over if Daniel is unable to fulfill his duties. 6. Best practices for non-resident guardians. Build a support network. Establish relationships with local caregivers, attorneys, and financial advisors who can assist with the ward's needs. Adopt technological solutions. Used digital tools for remote communication, financial management, and health monitoring. Plan for visa requirements. Work with an immigration attorney to secure a visa that allows periodic visits to the U.S. for guardianship-related duties. Seek legal advice. Retain a guardianship attorney familiar with cross-border issues to navigate the complexities of NY law and ensure compliance with court requirements. 7. Legislative and policy considerations. Existing gaps in the law. While NY law permits non-resident guardians, it lacks specific provisions addressing the unique challenges faced by those living abroad. This can lead to inconsistent outcomes in court decisions and difficulties for guardians. Potential reforms. Clear guidelines for non-resident guardians. Introduce legislation clarifying the responsibilities and limitations of guardians residing outside the U.S. Use of technology. Encourage courts to adopt remote reporting and monitoring systems for non-resident guardians. Facilitation of visa access. Create a special visa category for guardians of U.S. residents, allowing them to travel to the U.S. for caregiving duties. 8. Ethical considerations. Balancing interests. Courts must balance the ward's best interests with the guardian's ability to fulfill their duties. Appointing a non-resident guardian may raise questions about whether the ward's care could be compromised by the guardian's physical absence. Respecting family dynamics. Family ties and cultural values often play a significant role in guardianship decisions. Courts must navigate these dynamics sensitively, especially when family members are separated by borders. In conclusion, guardianship cases involving non-resident guardians in NYC and NIS highlight the complexities of cross-border caregiving and the need for thoughtful legal and logistical solutions. While current laws allow non-residents to serve as guardians, practical challenges related to immigration, communication, and financial management require innovative approaches. By adopting best practices and advocating for legislative reform, families and courts can work together to ensure that wards receive the care and protection they need, regardless of geographical boundaries.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa & Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.